Thank you. Welcome back, everyone, and thank you for your time. We're just going to go to the decision in the matter of the Licensing Act 2003 application for review of a premises licence at Danny Mart 2 Ludlow Road, Paulsgrove, Portsmouth. All parties shall receive written confirmation of the decision and the reasons. The decision. The subcommittee has considered very carefully the application for a review of a premises licence at Danny Mart. It gave due regard to the Licensing Act 2003, the licensing objectives, statutory guidance, and the adopted statement of licensing policy. The subcommittee considered the relevant representations, both written and given orally at the hearing, by all parties. Human rights legislation and the public sector equality duty has been borne in mind whilst making the decision. The subcommittee noted that the application was made by Hampshire Constabulary, citing the prevention of crime and disorder and the protection of children from harm as the relevant licensing objectives. The issues raised relate to the provision of CCTV on request. On 2 occasions, police evidence indicates that the premises were either unable or unwilling to provide CCTV footage to assist with the investigation of the alleged crimes at the store. This is despite repeated and concerted efforts and reported remarks indicating a willful refusal to cooperate. The failure of the recording system will have rendered sales of alcohol to be in breach of the licence. Representations in support of the premises licence holder have been received from other persons as defined by the Act. One representation supported the review application and a representation has been received from a local councillor. No representations have been received from any responsible authorities other than the police. After having heard all of the above evidence and considering all the options set out within the legislation, ranging from taking no action to the revocation of the premises licence, the subcommittee determined that the conditions of the licence should be modified to replace the CCTV condition with the wording proposed and to issue a warning to the premises licence holder. Reasons. The police stressed, amongst other matters, the following: that this was a consistent breach over a lengthy period of time. The matter was only rectified after review proceedings were commenced, that the premises licence holder has not been truthful as to the timing of becoming aware of the breach of the condition, and comments were not born of frustration, that this is proportionate to revoke the licence. A warning was not likely to be effective as a previous warning had been given. The investigation of assault was stalled due to a lack of evidence and CCTV not being available. The subcommittee was asked, if minded not to revoke, to consider the removal of the DPS with a suspension of 3 months to allow the changes to be implemented. Amongst arguments raised for the premises licence holder, the following was stated: the only identifiable issue as cause for the review proceedings is the lack of confidence held by the police, twinned with an unwillingness to engage. The 2016 incident was a result of fraud undertaken by a customer and was not related to the sale of alcohol. For the latest incident, he was not fully informed of the nature of the incident. The licence holder has cooperated with the police on numerous occasions, citing occasions that CCTV has been provided at the store and other times he has assisted the police, not limited to occasions where might be of benefit to him. Adverse comment was a result of frustration resultant from thefts at the store and not a sincere refusal to cooperate with the police. The system was not recording at full capacity due to an upgrade and adjustment by the installer. The premises licence holder is responsible for 2 premises over 10 years for each, has invested in and upgraded the system. There are updated systems/procedures for access to recordings at the store. Member of staff concerned no longer employed at the store. Backlash against the premises licence holder personally on social media. He acted promptly when proper information conveyed to him. The premises licence should not have made frustrated remarks and has apologised for those comments. There is a lot of support from the community. If revoked, it will certainly lead to a failure of the business. A warning is appropriate and proportionate response to calls of review. It was requested that condition 1 of the licence has been removed and replaced with suggested wording, which was handed to the subcommittee and the parties allowed to review during the hearing. The subcommittee accepted the police are the lead and experts for crime prevention licensing objective, but was required to consider all the circumstances of the case. All options in accordance with the legislation were considered, and the subcommittee does have serious concerns with regards to the behaviour of the licence holder and the quite apparent lack of cooperation, particularly the lack of proactive engagement. While it is accepted that technically and specific inquiries may not have been made, i.e. direct requests for access to CCTV, the subcommittee expects much greater positive engagement with the police and all responsible authorities. It is disappointing that it has taken a review proceedings to solidify that response from the licence holder. However, given that the importance of the premises to the community due to the topography of the area, particularly the disabled and elderly, the financial impact that revocation or even suspension might have had on a small business of this size, it was felt that despite the unfortunate lack of action following police warning, a further final warning should now be issued along with the amendment of the licence. Removal of the DPS was considered carefully. However, given that the licence holder would remain in overall control and in light of a period of experience in running similarly licensed business, and the fact that he has not appeared to be an objection to his remaining DPS for the other business, it was felt not appropriate in this case. There is a right of appeal for all parties to the Magistrate Court within 21 days of formal notification of the decision. The decision has no effect until the expiry of appeal or if lodged the determination of any appeal. That is the end of today's proceedings. We will get a written copy out to you. Thank you.
Thank you, councillors. And just to finally conclude by saying that obviously Nando will take on board the fact that this is a final warning and just repeat his commitment to working with the police in future. It's always difficult when review proceedings are brought by the police against a licence holder because you think that relationship has broken down. Knowing the police officers as I do and knowing my client as I do, just wish to reassure the committee that they will be working together in the future and it will be a successful relationship.
Thank you. And I will say what I say to all review people, please don't come here again. Thank you.